Let's discuss warranty. What is a warranty? The Philippine Legal Encyclopedia defines warranty as a collateral undertaking in a sale of either realty or personalty, express or implied, that if the property sold does not possess certain incidents or qualities, the purchaser may either consider the sale void or claim damages for breach of warranty. The warranty is a contract in which the implied promise is that the seller will pay damages if the property does not possess the characteristics warranted or if protection is not furnished, and the consideration of this promise is the making of the contract of sale. In Ang versus Court of Appeals, it's a September 29, 2008 case, the Supreme Court defines warranty as a statement or representation made by the seller of goods contemporaneously and as a part of the contract of sale having reference to the character, quality, or title of the goods, and by which he promises or undertakes to ensure that certain facts are or shall be as he then represents them. So, what are the kinds of warranties? They are express or implied, and these were mentioned earlier. Express warranty is imposed by the parties. It can be warranty relating to the contract or transaction, warranty relating to the object of the contract, or warranty relating to the party of the contract. For implied warranty, it's imposed by law. Let's further discuss what an express warranty is. What is an express warranty? An express warranty is defined in express warranty is defined in Article 1546 of the Civil Code. Any affirmation of fact or any promise by the seller relating to the thing is an express warranty if the natural tendency of such affirmation or promise is to induce the buyer to purchase the same, and if the buyer purchases the thing relying thereon. From that definition, under Article 1546, we can now tell what the requisites of an express warranty are. All right. So, what are the requisites of express warranty? Okay. There is an express warranty when the following requisites are present. Number one, an affirmation of fact or any promise by the seller relating to the subject matter of the sale. Okay. So, number one is affirmation of fact or any promise by the seller. Number two, the natural tendency of such affirmation or promise is to induce the buyer to purchase the thing. And number three, the buyer purchases the thing relying on such affirmation or promise. To better memorize, to, to memorize this easier, you can use the acronym AIR. A for affirmation, I induce, and R rely. Okay, so affirmation of fact, that affirmation of fact or promise induce the buyer to purchase the thing, and the buyer purchased the thing relying on such affirmation or promise. Those are the requisites of express warranty. Let's go to implied warranty. What is an implied warranty? An implied warranty is that which the law derives from the nature of the transaction or the relative situation or circumstances of the parties, irrespective of any intention of the seller to create it. So basically, it's imposed by law. Implied warranty is imposed by law. These are the implied warranties in a contract of sale. Under Article 1547, that's warranty as to title. Article 1548, warranty against eviction. Article 1560, warranty against non apparent burden or servitudes. Article 1561 of the Civil Code, warranty against hidden defects or encumbrance. Article 1562 of the Civil Code, it's warranty as to quality or fitness of goods. Article 1576, that's warranty against redhibitory defects on animals. And warranties for consumer goods under Article 68 of RA 7394 or the Consumer Act of the Philippines. Sorry about the typo. The, it would appear that there's a $500, $50 gift certificate there. That's not included in the slide. It's part of the template. I think I wasn't able to delete it. Anyway, when is an implied warranty inapplicable? Okay, implied warranty is inapplicable in the following instances. First is it's inapplicable in as is and where is sale, or when the vendor makes no warranty as to the quality or workable condition of the goods. In this case, the vendor takes them in the condition in which they are found and from the place where they are located. That is, as is and where is sale. Another scenario when an implied warranty is inapplicable is the sale of second-hand articles. You can check out Molas versus Intermediate Appellate Court, January 31, 1989, for that exception. And then another one is sale by virtue of authority in fact of law. When is there a breach of warranty against eviction? Okay, there is a breach of warranty against eviction when the following requisites concur. First, the vendor should be deprived in whole or in part of the thing purchased. Second, the deprivation is by virtue of a final judgment that's provided under Article 1557 of the Civil Code. Take note, this warranty cannot be enforced until a final judgment has been rendered, whereby the vendee loses the thing acquired or part thereof. Another requisite is the third requisite is judgment is based on a right prior to the sale or an act imputable to the vendor. That's under Article 1548 of the Civil Code. The fourth requisite is the vendor was summoned in the suit for eviction at the instance of the vendee to enable the seller to prove his claim, to avoid multiplicity of suits, and to satisfy due process. Number five is no waiver of warranty by the vendee. That's under Article 1554. So basically, there is a breach of warranty against eviction when the following requisites concur. Rec- you check out Articles 1557, 1548, 1558, and 1554, plus this requisite, which is vendees deprived in whole or in part of the thing purchased. So those are the requisites in order to prove that there's breach of warranty against eviction. Remedies of an aggrieved vendee in case an eviction takes place. So, what are these remedies? In case an eviction takes place, an aggrieved vendee has the following remedies. First, in case of total eviction, the vendee shall have the right to demand from the vendor the following: return of the value which the thing sold had at the time of the eviction, income or fruits if he has been ordered to deliver them to the party who won the suit against him, cost of the suit, expense of the contract, and damages and interest and ornamental expenses if the sale was made in bad faith. You can check Article 1555 for that. Another remedy, the second remedy of the vendee, in case of partial eviction, the vendee may demand rescission of contract or enforce the vendor's liability for eviction under Article 1555 of the Civil Code. And that is provided under Article 1556. What are the effects of a waiver of warranty against eviction? For the effects, you may check out Articles 1553 and 1554. Any stipulation exempting the vendor from the obligation to answer for eviction shall be void if he acted in bad faith. Also, the following rules shall apply. First, in case of waiver, consciente or simple, if the vendee has renounced the right to warranty in case of eviction and eviction should take place, the vendor shall only pay the value which the thing sold had at the time of the eviction. Second, in case of waiver intentionada or calificada, should the vendee made should the vendee have made the waiver with knowledge of the risk of eviction and assume its consequences, the vendor shall not be liable. Even when there is no specific waiver, one who purchases real estate with knowledge of a defect or lack of title in his vendor cannot claim that he has acquired title thereto in good faith. When the buyer cannot show that he is a buyer in good faith, he is not entitled to the warranty against eviction, nor he is entitled to recover damages under Article 1555 of the Civil Code. When is there a breach of warranty against hidden defects? Okay, there's breach of warranty against hidden defects when the defect is hidden. Okay, the defect must be hidden. Second, the defect must exist at the time the sale was made. Third, the defect must ordinarily not have been excluded from the contract. Fourth, the defect must be important. For example, it would render the thing unfit or considerably decrease its fitness. And number five, action must be instituted within the statute of limitations. We will discuss the prescriptive period later at the end part of this lecture. So, what are the remedies of a buyer in case of breach of warranty against hidden defects where the thing has not been lost? In case of breach of warranty against hidden defects where the thing has not been lost, the buyer may exercise either of the following remedies with damages in either case. Okay, there are two remedies: action redhibitoria and action quanti minoris. Okay, you check out Article 1567 for that. Action redhibitoria is an action to withdraw from the contract. Action quanti minoris is an action to demand a proportionate reduction of the price with damages in either case. So these are the remedies of a buyer in case of breach of warranty against hidden defects where the thing has not been lost. Action redhibitoria or action quanti minoris. What are the remedies of a buyer and or obligations of a seller in case of loss of the thing due to breach of warranty against hidden defects? The remedies of a buyer and or obligations of the seller in case of loss of the thing due to breach of warranty against hidden defects are as follows. It would matter if the seller was aware of hidden defects or if he was not aware of the hidden defects. And if the thing sold is lost as a consequence of hidden faults, or if the thing is lost through a fortuitous event or through the fault of the buyer. So, to answer this question, kindly check out Articles 1568 and 1569. So, let's go to when the thing is lost as a consequence of hidden faults and the seller was aware of hidden defects. Okay? Then the remedy there is the effect there is the seller shall bear the loss and shall, first, he shall return the price. Second, may refund the expenses of the contract only when the buyer paid for them. And number three, pay for damages. But what if seller was not aware of hidden defects and the thing is lost as a consequence of hidden faults? Then the seller there shall return the price and interest thereon and reimburse the expenses of the contract when the vendee might have paid, which the vendee rather might have paid. So the seller, if he was not aware of the hidden defect, but the thing is lost as a consequence of hidden faults, then the seller shall return the price and interest thereon and reimburse the expenses of the contract with which the vendee might have paid. All right. Let's go to the scenario when the thing is lost through a fortuitous event or through the fault of the buyer and the seller acted in bad faith. Then the seller must pay damages to the vendee. But what if the seller was not aware that the thing is lost and the seller was not aware and the thing is lost through a fortuitous event or through the fault of the buyer? Then the buyer may demand from the vendor the price which he paid less the value which the thing had when it was lost. So those are the remedies. Again, you may check out Articles 1568 and 1569 for that. What are the warranties of a seller in a contract of sale by sample? The seller who is a dealer in goods and in that kind of when the seller who is a dealer in goods in that kind warrants the following. First, that the bulk of good delivered correspond with the sample shown by the buyer. That's in Article 1481. And second, that the goods shall be free from any defect, rendering them unmerchantable, which would not be apparent or reasonable on reasonable examination of the sample. That's under Article 1565. Let's go to the remedies of a seller in a contract of sale by not by sample. This is a typo. Okay, just disregard the power this particular slide. 1481 and 1565 refer these articles refer to the warranties of a seller in a contract of sale by sample. Okay. What are the remedies of a buyer in case of breach of seller's warranty? Okay, in case of breach of seller's warranty, the buyer may, at his election, avail of the following remedies. Number one, recoupment. It means accept the goods and set up the seller's breach to reduce or extinguish the price. Number two, accept the goods and maintain an action for damages for breach of warranty. And number three, refuse to accept the goods and maintain an action for damages for breach of warranty. Or number four, rescission, which means rescind the contract and refuse to receive the goods, or if goods have already been received, return them and recover what was paid or any part of it concurrently with the return or immediately after it. Okay, these remedies are alternative. Okay, meaning they don't have to go together. But without prejudice to paragraph 2 of Article 1191 of the Civil Code, which provides that a party may still seek rescission after choosing specific performance. Okay, if the specific performance becomes impossible, kindly look at 1599, also Article 1599. What are the consequences of the buyer's election to rescind? In case of breach of warranty by the seller in the sale of goods, the buyer's election to rescind the contract of sale has the following consequences. Okay. One, he shall cease to be liable for the price upon returning or offering to return the goods. And number two, if the seller refuses to accept an offer of the buyer to return the goods, the buyer shall be deemed to hold the goods as bailey for the seller. In number one, I have mentioned the consequence one of the consequences is he shall cease to be liable for the price upon returning or offering to return the goods. Take note that if the price or part thereof has already been paid, the seller shall be liable to repay what has been paid and to return the goods. In the number two consequence, I've mentioned earlier, if the seller refuses to accept an offer of the buyer to return the goods, the buyer shall be deemed to hold the goods as bailey. Take note that this is subject to a lien to secure payment of any portion of the price which has been paid, and with the remedies for the enforcement of such lien allowed to an unpaid seller by Article 1526. When is the buyer not entitled to rescind the sale, even in case of breach of warranty? Okay, you can also check out 1599 for that. Should the goods have been delivered to the buyer, he cannot rescind the sale in any of the following instances. Number one, if he knew of the breach of warranty when he accepted the goods without protest. Okay, so he knew, that's number one. Number two, if he fails to notify the seller within reasonable time of the election to rescind. So number two is if he fails to notify within reasonable time. Number three, if he fails to return or to offer to return the goods to the seller in substantially good condition as they were at the time the ownership of the transferred at the time the ownership was transferred to the buyer. So number three, if he fails to return or to offer return to the goods to the seller. Take note, if the deterioration or injury of the goods is due to the breach of the warranty, such deterioration or injury shall not prevent the buyer from returning or offering to return the goods to the seller and rescind the sale. Let's go to the prescriptive periods. What are the prescriptive periods for breach of warranty against hidden defects of or encumbrance upon the thing sold? Okay, the prescriptive periods for the breach of warranty against hidden defects are as follows. For implied warranty, rescission or proportionate reduction of the price for action quanti minoris is 6 months from the date of delivery of the thing sold. That's under Article 1571 of the Civil Code. For express warranty, it should be in accordance with the stipulation of the parties. Or if the if there's no stipulation of the parties or in the absence of stipulation, the prescriptive period is 4 years from the time the action for rescission accrues. That's that's Article 1389 of the Civil Code. If the action is based on quasi-delict, the prescription is within 4 years from the time the right of action accrues. When is the right of cause of action accrues? Okay. Usually it's the period or the date when the injury is sustained. And when you talk about prescriptive period, it's it's the date. I mean, the when you say the start of the prescriptive period, it's the date on which the clock begins. So that's the reckoning point. And the reckoning point is usually the the time the right of action accrues. Okay? When does an action accrues? When the cause of action accrues. And what is a cause of action? A cause of action has three elements: the legal right of the plaintiff, the correlative obligation of the defendant not to violate the right, and the act or omission of the defendant in violation of the legal right. Okay? And on the date of the violation of that legal right, that's the start of the count of the period. As discussed earlier, there are also warranties for consumer goods under RA 7394. Implied warranties. Kindly go over RA 7394 and answer the following questions. What is the nature and extent of liability of the retailer in case of breach of warranty for consumer goods? The duration, what is the duration of the enforceability of warranty for consumer goods, and what are consumer products and services? Okay, and kindly submit your answers before 12 midnight on October 8, 2021. I'm gonna assign an assignment through Google Classroom. You just have to send your answers there.